You are listening to Breaking Boundaries with Brad Palumbo.
Hey everybody, and welcome back to the show. I've got a great guest here with me this week, Ilya Shapiro of the Cato Institute. He's the director of the Robert A. Levy Center for Constitutional Studies and the author of a new book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. Yep, there's the book cover, everybody. It's on Amazon now, and frankly, the book could not be more relevant now than it is right now, given the fact that the late Ruth Bader Ginsburg has passed and that President Trump has nominated Amy Coney Barrett to replace her. To start, Ilya, thanks for joining the show.
Good to be on, and yeah, the publisher had to pay extra for that kind of timing.
Yeah, I guess you never want anything bad to happen, but you are tied into the news now with your launch in a way that I guess a publisher can only dream about. So maybe to start, let's just talk a little bit about the Supreme Court itself. I think the Supreme Court, and I bet you would agree with this, is one of the most misunderstood institutions in American life. What do you think?
Well, the level of civics education these days, I think most institutions are misunderstood, but certainly the way the legal process works and how it culminates at the Supreme Court, I'm sure that seems mystifying to a lot of people, and particularly after watching this week's confirmation hearings where the Democratic senators made it seem like, well, you obviously a judge is supposed to rule for whoever the most sympathetic litigant is in front of them.
Well, and also it's just not the case that the Supreme Court can clap their hands and say, let's rule on gay marriage today, right? So could you talk a little bit about the process that has to happen before the Supreme Court can issue a ruling and how that constrains their ability to just kind of have this outsized importance that people seem to think they do sometimes?
Right. The court, no court is a self-starting institution. It doesn't just decide, I'm going to make a ruling on the Commerce Clause or guns or whatever on any given day. Somebody files a lawsuit because they feel that a government action or legislation has violated their rights, or they've been hurt by a government action they think goes beyond the power of that agency, or beyond federal power, or whatever the case might be. And that goes to the district court, which then there's an appeal to the circuit court level in the federal system if there's a federal question. And then you petition the Supreme Court, and the Supreme Court takes fewer than 1% of petitions that are filed with it. So the cases are all lawyered up, and you have a specific question that's presented at issue in the case. And that's what the court rules on.
So with the passing of Ruth Bader Ginsburg and the nomination of Amy Coney Barrett looking about certain to go through at this point, I mean, you never know in today's politics, but it looks like a sure bet that she'll be on the court. First, how do you see that changing the court? Obviously, it was a 5-4 conservative-leaning majority with John Roberts as kind of this institutionalist swing vote, sort of. But will the 6-3 be a big difference, or will it not be that big a difference?
It will in some cases. That's the thing. You mentioned John Roberts is an institutionalist. So, he's surprised and frustrated conservatives and libertarians in different kinds of cases, but it's not because he's a squishy moderate like Anthony Kennedy, or that he's evolved or moved left in office like other Republican-appointed justices like Souter or Stevens. It's that, especially as Chief Justice, and we haven't had a Chief Justice as the median vote in over half a century, he thinks about more than just what is the correct view of the law. He thinks about how is the court perceived, how can I maintain the court's legitimacy, these sorts of questions. Now, I would say he shouldn't be doing that, and in doing so, it's counterproductive. The court is actually seen as less legitimate when justices think about legitimacy or other things that aren't about just how do I view the law. But anyway, that's what he's been doing in the couple of years, at least, since Kavanaugh replaced Kennedy, making Roberts the middle of the court. With Barrett joining the court, he becomes the sixth vote, not the fifth. And so cases that were 5-4, conservatives over liberals, as it were, become 6-3. Cases that were John Roberts plus the liberals become 5-4 the other way. So
where could they become 6-3?
Or they could become 6-3, I suppose. If Roberts is trying to be strategic, and again, they could. It could that kind of shift could happen as well. Now, where does that? What kinds of outcomes would that mean a shift in? Probably not free speech cases or even campaign finance cases. Roberts tends to be with the conservative on those, so that wouldn't change. Affirmative action. There's the Harvard case that's been winding its way through the courts that they're discriminating against Asians, and Yale is now being investigated by the Justice Department for the same reason. It's been a while since the court, the last time there was a case in UT Austin, which is with its peculiar type of racial preferences, and Kennedy joined with the liberals for a 5-3 decision after Scalia passed. I think that was shifting already with Kavanaugh replacing Kennedy. So I think the next time that we get a racial preferences in education case, that will be 6-3 rather than 5-4. So Barrett joining the court probably wouldn't change that ultimate result. But where it might change the result would be in abortion regulation cases. We had one of those this past term. Not overturning Roe versus Wade, but just some regulation in some states, some restriction where might be what might be struck down will now be upheld at the margins.
So on that point, actually, there's so much fanfare that is made about Roe v. Wade and what Amy Coney Barrett will mean for it. But I mean, from the legal scholars I listen to, it doesn't really seem like that's actually at stake. I mean, you have Thomas would overturn Roe, maybe Alito, and maybe Barrett, but there's no way you have 5 votes for that, right?
I think that's exactly right. And she has said as much. I mean, she's given speeches saying that the underlying right is not in question. She can't see the court in coming years doing that. So it might be one more vote. And, the Justice Ginsburg herself has criticized Roe v. Wade for the court short-circuiting the political process and doing it all wrong and at the wrong time. And I think she's right. It's poisoned our political discourse, our legal discourse going on 50 years almost now, because there's so much more to the law than just abortion. The other thing, of course, that the Democratic senators at this confirmation hearing made a big deal of was the Obamacare case that's coming up on the Supreme Court docket this turn. Mm-hmm. And that's even more sort of emotional political appeal and demagoguery, because I don't think there's a single vote to overturn the entire Affordable Care Act based on this case. It's not simply a do-over of 8 years ago when John Roberts came up with his taxing power transmogrification to uphold the law. Things have changed. The legal issue is different. And so Amy Barrett, again, is not the 5th vote to overturn that. She, isn't even the first vote.
Right. Democrats have basically turned her confirmation hearing into a speech about why Obamacare is good, because they're just making it all about a referendum on Obamacare. And you point out if I go anywhere wrong with this, but just for listeners, the Supreme Court will hear a case where people are challenging the constitutionality and legality of Obamacare because the individual mandate has been zeroed out. But my understanding, and you tell me what you think of this, is that they probably will strike down the mandate but sever the rest of the law and leave it in place. Yet Democrats are acting like they're going to axe the whole thing. Do I have that right?
That's right. The one thing I'd just correct is it's not the mandate has been zeroed out. It's the tax that John Roberts called it was zeroed out, and therefore the mandate is no longer sustainable under the taxing power. But yes, now Cato filed a brief with my friend Josh Blackman, having a more nuanced remedy take on this. There are private plaintiffs here, not the states, but there are a couple of private plaintiffs buying policies in the individual market. So it's not an employer provided policy, but the individual market, not on the Obamacare exchanges. And we argue that there can be a remedy crafted for them to excise certain other provisions that hurt them and make their insurance more expensive. But that's a very technical, nuanced argument that has nothing to do with, upsetting the entire law.
So the one other thing that kind of Democrats and liberal activists have really raised the alarm about is gay marriage. And obviously, this is an issue that's kind of relevant to me. But I actually don't think there's from my observations, any real chance they would ever overturn Obergefell, the 2015 decision that declared gay marriage the law of the land in all 50 states. And I have 2 questions about that. One, I don't think the votes are there. But two, is it even possible that the Supreme Court could get a case that would allow them to do that? Because my understanding, and maybe you could explain this, is that somebody would have to have a claim that would go through the system. And the way that gay marriage works, I don't see how that could happen.
Yeah, both of those points are valid. My colleague Walter Olson has written about this. He's in a same-sex marriage himself. And he says, between reliance interest and the way that popular opinion was shifting, this could have been another case kind of like Roe, where the court kind of short-circuited the political process, where it was going in that direction anyway. Unlike Roe, however, the popular opinion has continued shifting. So it's not that, 40 years down the line, we'll still have, a 50-50 nation on the question. We won't. And also the reliance interests are a little different, because with tens and thousands of couples married, what does exactly mean if you overturn that? Whereas with abortion, obviously, you're only pregnant for 9 months at a time. But the other point, that's right. How would you even challenge that? Would it be a state reimposes a bar on same-sex marriage, but then the couple would go to the district court, get that struck down immediately, and the Supreme Court wouldn't need to take that up at all. So it's hard to see that scenario.
Who would have standing? Who would have standing to take that through the system?
Well, again, if a state says, "Oh, we're reimposing our bar on same-sex marriage," and then anybody who would want to get married in that scenario would then again go to the district court and the same day get it struck down. I
have to say, I follow kind of the activist chatter, and they're screaming about gay marriage. They're screaming about Amy Coney Barrett using the term sexual preference, and it just all seems like alarmism to me. I don't think that she will be a vote to kind of actively pursue LGBT rights from the bench, but I think she'll follow the law. And for example, if legislation was passed through Congress, do you think that Amy Coney Barrett would be going out of her way to undermine it, or was she just not going to be a judicial activist in favor of kind of passing those things from the bench?
Well, I think she would, hold Congress's feet to the constitutional fire, and it depends on the type of case. These things are pretty nuanced, but yeah, she hasn't shown in either her judicial or academic writings a proclivity for imposing her policy views, whatever they may be. She's very careful and thoughtful. I have my disagreements with her because just like her mentor, Justice Scalia, whom she said his jurisprudence is basically mine, doesn't mean exactly the same. And she made that point. You'd be getting a Justice Barrett, not another Justice Scalia. But that means I think that she'd be too deferential to state infringements on economic liberty, for example, and her critique of Randy Barnett's book, Our Republican Constitution, where she effectively endorses rational basis review, meaning just deferring to state legislatures when they pass economic regulations of various kinds. So I don't think she's going to go out of her way, whether it's on gay marriage or anything else, to do some radical thing. But yeah, the whole sexual preference thing, I don't know why when you have these lexicographical disputes and the supposed dog whistle is only heard by those who are not the bigots or not the supposed, targets of a reactionary agenda or something like that. Again, I don't really, work those fields or what have you, but that's a tempest in a teapot.
Yeah. So I think it's just true that Amy Coney Barrett is eminently qualified, and I've been impressed with her so far. But maybe for people, you could help us understand kind of just what it means to be an originalist. Can you kind of give a layperson a definition of that?
Yeah, she was asked that question, I think by Ben Sass. She says, in English, tell us what being an originalist and a textualist means. And it doesn't mean what my Twitter feed has been filled up with. Oh, we want to cook our food over an open hearth and drive in horses and buggies, and women shouldn't vote and all of this. No, it means all of the Constitution. You interpret the text according to what it meant when the text was enacted. So the 19th Amendment, women being able to vote, is part of the Constitution. So a good originalist would look at that provision and say, the right to vote can't be denied according to sex. Case closed, right? It has nothing to do with the meaning of voting in 1789 or anything like that. Same thing with slavery. The 13th Amendment is part of the Constitution. It's like, well, in 1789, we had slavery. I guess we're going back to that. Not at all. A good originalist looks at not even the intent of, say, James Madison writing the Commerce Clause, but at what does commerce mean? And it turns out in the late 18th century, commerce did not mean manufacturing or agriculture. It meant exchange in goods, the interstate exchange in goods. That is the power of regulation that Congress got under that provision. Textualism is similar. In fact, the shorthand way of explaining textualism is that it is originalism for statutes, so for the laws that Congress passes. And typically, it's not as difficult because most laws that courts are called upon to interpret were not passed in the year 1800 or 1868. Right. They're more modern. And so, what does the Clean Water Act mean? Well, let's see. Congress passed it in 1972, I think, 70, something like that, and then amended it several times. So you look at what does the meaning of particulate matter mean in a dictionary from 1975 or something. Chances are it's no different than what it means in 2020. Or to take a controversial from this term, the Bostock case about whether Title VII of the Civil Rights Act of 1964 and its prohibition on adverse employment actions because of sex, whether that includes protections for sexual orientation and gender identity. This past term, in an opinion by Justice Neil Gorsuch, the court ruled 6-3 that because of sex does include gender identity and sexual orientation. Why? Is it because the meaning of the words change, or we are going towards an ever more just union, and so we evolve to have greater civil rights protections? Well, no. Gorsuch was in this case, I think, a hyper-literalist, too much of a textualist, and saying, well, sex is inextricably connected to concepts of gender and sexual orientation, that sort of thing. Kavanaugh, in dissent, I think, also a textualist, had the better of the argument, saying, no, you have to be a good textualist. You don't take words in a vacuum. You look at the plain meaning of the phrase, and even in 2020, forgetting what anyone would have thought or intended in 1964, just the meaning of the words, even in 2020, if someone's fired for being gay, we don't say that they're fired because of their sex.
Well, let me ask you about this, because this was a really interesting one, because it almost showed, from the layperson's point of view, a conflict between textualism and originalism, right? Nobody thinks that the framers of the, or the people who wrote Title VII intended it to cover sexual orientation. They did not. But they did intend it to cover biological sex, which it does. And I was convinced by Gorsuch's argument that you can't discriminate against someone on the basis of their sexual orientation without sex being a but-for cause of that discrimination. Because if I'm fired from my job after I marry a man, a woman wouldn't have been fired for the same thing, a biological woman. So sex is the but-for cause there, no? Or it's one of them?
No, because you can rephrase that kind of hypothetical and to say that men and women are being treated equally because both men and women can't marry someone of the same gender. So you can rephrase that to have it being treated equally without regard to sex or differently, as you said, and ultimately it's not a conflict between originalism and textualism, because again, originalism purely applies to constitutional provisions. So it's a debate between different kinds of textualism, and Gorsuch's version has been called hyperliteralism rather than textualism. I think he kind of went too far. I mean, it's true that gender identity and sexual orientation are inextricably connected to sex, to the word sex, to the idea of sex, to that concept. But the phrase is adverse employment action, quote, because of sex. So if someone's, that phrase, the way a native English speaker would understand, being fired or not being promoted or not being given a raise because you're gay, you wouldn't generally say, well, I was discriminated against based on my sex. I mean, it's not the most natural reading of that text.
So how can we expect Amy Coney Barrett to fit in on the court, and kind of, because all the justices on the right of the court are not the same, right? Like you've explained this before. Thomas is different from a Gorsuch, who's different from a Kavanaugh. So where will she fit in terms of the kind of originalist to textualist, middle to right, a scale of the court?
It depends on the issue, because I think the constellation works differently, whether it's a federal power claim, administrative law, individual rights, criminal procedure. All of these things align differently because of the way that the different justices apply their originalism, or consider prudential doctrines, whether it be stare decisis. That is, Thomas, for example, has never met an erroneous precedent he wouldn't overturn, whereas Scalia, who Barrett is very much like, is much more cautious. Gorsuch probably closer to Thomas, but somewhere in the middle there. On law enforcement issues, Justice Alito is much more deferential, whether it's a free speech case or whether it's a criminal procedure case. He is going to defer to law enforcement more than any of the others. There's a rich, vibrant diversity, intellectually speaking, I think, on that side of the court. And it's kind of ironic. Senator Sheldon Whitehouse likes to harangue the Roberts Five that are, bought and paid for by the big business lobby and all of this. But it turns out that either the court is unanimous or near unanimous on business cases, or in those 5-4 decisions, it's what was the Ginsburg Four that are much more united than the Roberts Five. I had an op-ed in USA Today just over a year ago, statistically showing that it's that Ginsburg Four that's much more in lockstep. Not necessarily because they're acting in bad faith or they're result oriented. I'm not smearing them in that way, but the legal theories on the left, whether you call it pragmatism or looking at the purpose of a law or seeking justice, or Breyer calls his mode active liberty, that gets you to the same place in the end on those ideologically salient controversies.
Well, let me ask you about that, because I feel like I got a grasp from what you just said of textualism and originalism, but what is the kind of liberal alternative? I've heard living constitutionalism. What exactly is the framework they apply?
Yeah, for constitutional provisions that are indeterminate, I suppose, or have a range of meanings, they would pick the one that achieves a sense of justice as they see it. So
they just align with their preferences?
Well, it's almost figuring out how many angels are dancing on the head of a pin. They do align with their preferences, but not, if you ask them, it's not because they're imposing their preferences. It's because they think, well, equal protection means equality. How do I define equality in this particular case? Or, my idea of active liberty, and does this interpretation promote that conception of liberty or harm it? It's almost like imposing their policy preferences, but not quite in so many words.
But how can you have any sort of limit on that? I've always kind of raised an eyebrow at the idea, because I studied constitutional law in college, and you'd read a decision and it would say it would be based on the spirit of the Constitution.
Yes.
And it's like, if the law can mean anything, then doesn't it mean nothing?
Yes, there are no limits. It's like when Obama's Solicitor General, Don Verrilli, was asked for a limiting principle during the Obamacare argument. If the government can force you to buy health insurance, what can't it force you to do? There was no limit. There's certain things, like it can't force you to, violate your bodily integrity in certain ways, or if it infringes on a 14th Amendment right, or censorship or something like that, where you're bringing a First Amendment claim. But just in terms of the power granted is limitless. So there you go.
Now, how would somebody like a Merrick Garland have fit in terms of this ideological, for reference? Like, what would a moderate liberal justice look like in today's context?
So from a libertarian perspective, it's probably worse than a radical progressive, because at least a Justice Sotomayor often gets to the place where I like on criminal procedure, or interpreting the Fourth Amendment or the Sixth Amendment, as was Scalia, by the way. He was a big supporter of criminal defendants. He's like, I don't want these guys getting off, but they have their constitutional rights, that sort of thing. Whereas a Merrick Garland would defer to the government, including and especially in law enforcement capacities.
And do you think there will be motion on one of the issues I found most frustrating is the Supreme Court just ducking the Second Amendment? I care a lot about the Second Amendment. I think a lot of the laws that are passed facially seem to run against the Second Amendment, just obviously. And maybe there's a legal reason
you want gay married couples to protect their marijuana with semiotic rifles. Absolutely.
That is what I want. And but I would like to see, I don't understand why they've dodged the cases, but also, do you think that having Amy Coney Barrett on it will finally see some of these things at least engaged with?
Yes. So to answer your last question, yes, this is an area that I think will make a difference. So for about a decade, the court was not fleshing out the scope of the Second Amendment after, in the Heller case in 2008, determining that it was an individual right, and then 2 years later extending that right to the states. But it wasn't fleshing out its scope. And so the lower courts are what I like to say willfully confused. Really, they're engaging in civil disobedience, some of the jurisdictions that are hostile to the right to armed self-defense. And so not only do they disagree in the outcomes in terms of, is a magazine restriction constitutional, or being able a restriction on the right to carry, whether open or concealed, but even the analytical rubric to apply to answer those questions, there are lots of different answers in different courts across the country. But the Supreme Court was derelict and did not take any of these cases, presumably because neither side knew how Anthony Kennedy would come down on the issue, and so they stayed away from it. Then Kennedy was replaced with Kavanaugh. Very quickly, they took up a Second Amendment case on possibly the most narrow Second Amendment restriction that could, and bizarre one that existed in the country. This is the New York State Rifle and Pistol Association case, where New York City prohibited even licensed firearm owners from transporting their firearm outside city limits, whether they're going to a second home or a shooting competition, a training range, or whatever else. They were sued, and the city won through the Second Circuit on appeal. The Supreme Court took the case 3 weeks after I wrote an op-ed in the Wall Street Journal urging them to take a Second Amendment case. So my rates for writing op-eds in support of interpretation is up, right? And then New York City and gun control proponents got scared off by that, had the city reverse its rule, and then the state legislature in Albany salted the earth over it, saying no municipality in the state can have such a crazy rule. And so ultimately at the Supreme Court, the case was mooted by a 6-3 vote, with Roberts and Kavanaugh sliding over to moot it, although Kavanaugh wrote a concurring opinion saying basically that he agrees with the dissent on the merits and that this issue needs to be fleshed out, and we have plenty of good petitions. Well, 6 weeks later, the court denied all 10 pending petitions, raising issues ranging from the right to carry to magazine capacity to a California law requiring the gun to microstamp each bullet as it exited the chamber, which is physically impossible. It's like saying you have the right to freedom of speech so long as you turn lead into gold or something like that. But anyway, declined all of those. Dissent by Thomas and Kavanaugh. I think if Judge Barrett becomes Justice Barrett, then that case will again, that sort of one of those cases will be taken up, and we'll finally have some movement in that area of jurisprudence.
Let me ask you about a pet issue of mine. I went to campus at a public university. I went to college at a public university, the University of Massachusetts Amherst, and it was a gun-free zone. So if you were a regular Massachusetts citizen, age 21, who lived in the town of Amherst, you could get a concealed carry permit and carry a gun walking around town. But if you were a university student, they just banned you from having the right to concealed carry anywhere on campus or having a gun carrying it. And it always struck me as, from a non-lawyer perspective, just facially against the Second Amendment, because it's not like you could declare your campus a First Amendment free zone. So why is that? Do you think that's something we could see addressed at some point, and would it succeed on the merits?
That would not be the first case I would take to the Supreme Court. I'd take, more cut and dry restrictions and regulations. This sort of thing involves two potential restrictions on the right to armed self-defense. One is that educational environments are so-called sensitive areas, just like government facilities and buildings are. And secondly, whoever owns property can control, what goes on there. And so it might be a little bit different if you're in your own home on campus housing or something like that, versus the right to carry into the classroom or something like that, or in, the areas where students congregate. those sorts of things there might be more leeway for the government to regulate. But you're right. You can't have a free speech free zone. So how can you have a gun free zone in many ways? But again, just like when libertarians talk about privatizing roads, well, okay, let's discuss that once we've hit the 99% of things that are a bigger imposition on our natural rights before we get to the who owns the roads scenario.
Right. That's I know there is this tendency to kind of talk about the niche stuff. So maybe let me ask you stuff that's closer to the top of the relevance to more people. So a Biden-Harris administration, what kind of judges at the federal and Supreme Court level could we expect from them?
Well, more like Sotomayor and Kagan. And he said two things Joe Biden has about the types of judges he'd appoint, or at least the first Supreme Court nominee he'd appoint. One is that it would be a black woman. So historically, as I write in my book, Supreme Disorder, Democrats have looked a lot at representational picks and trying to kind of balance out race and gender and now sexual orientation in their judicial appointments. The other thing Biden has said is that he's endorsed the theory of living constitutionalism, so that the words change over time as our understanding of justice changes over time. So so to put it another way, he's not looking at merit. He's not looking at enforcing a written constitution to be fixed. It's more of a loosey-goosey kind of, what is the just result?
I find that really off-putting, what you mentioned about his identity-based selection criteria. I mean, I'm sure there are lots of African-American women who would be great Supreme Court justices, but to openly narrow it like that and exclude other people, that kind of reeks of tokenism to me. I mean, how does that come across to you?
Especially when you think about the types of people that are generally considered eligible, not just for lower federal judges, but for Supreme Court justices, you probably want someone who's either a judge already, or like the Solicitor General, or maybe a senator. Historically, with people like this, Attorney General, that sort of thing, and who's young enough, under 55 is generally the modern age. There's not that many black women that fit that role. It's really, a handful, literally, 5 or 6. And so that even more gets towards tokenism. You're saying only these people are qualified that you're picking from. So it is. But that is what it is. I mean, that's Bill Clinton talked about having a cabinet that looks like America, and he and Obama talked about lower courts that look like America as well. So that's obviously that kind of identity politics is very much a consideration. For that matter, one of the biggest attacks on President Trump and his various the great impact that he's had in confirming judges is that there is little quote unquote diversity. There aren't any black women. There are, especially among the circuit judges, relatively low numbers of racial minorities. But then and women as well, for that matter. And then when women and racial minorities are appointed, those are the ones who get the most heat and get the sternest attacks. Whether Naomi Rao or Patrick Bumatai, the first Filipino American circuit judge, also happens to be gay. Senator Harris did get her to drop him. Jim Ho in Texas. So it's ugly. It's ugly racial and gender politics, to be sure.
So also, I guess we have to talk about court packing. I mean, Joe Biden and Kamala Harris, she outright supported it or said she was open to it during the primary campaign, and he's repeatedly now refused to take much of a stance, said you'll find out after the election. So just for listeners, the Constitution does not set the number of Supreme Court justices, but it's been at 9 since 1869, I believe. And it could technically be changed, but basically to add 2 seats to the court and stack it with ideologically friendly justices is something that was basically universally decried until a minute ago as authoritarian. So what do you make of the fact that Biden and Harris are flirting with this kind of proposal?
Well, I don't know about authoritarian I mean, Biden even said confirming Amy Barrett would be unconstitutional. Well, no, and packing the court would not be unconstitutional either. All it does take is an act of Congress, as you said. I mean, they would first procedurally have to get rid of the legislative filibuster, which still exists in the Senate for nominees, for judicial nominees and executive branch nominees. That's been eliminated, the nuclear option under Harry Reid and then Mitch McConnell for the Supreme Court. But for normal legislation, there's still a 60 vote threshold in the Senate to proceed to a final vote. They would have to eliminate that and then just pass a law adding however many seats. If Barrett's confirmed, they would need to add 4 seats to have a 7-6 Democratic appointed majority. And Biden is being coy because he neither wants to turn off independent voters, among whom court packing would not be popular, nor does he want to anger his base, which is calling for blood at this point. So historically, court packing has neither been popular nor inured to the benefit of the country. And it's also been short-lived. There have been kind of these tit-for-tat packing escalations going all the way back to John Adams and Thomas Jefferson at the very beginning of the 19th century. It has kind of a sordid and politically shenanigan type history.
But I mean, it is so. I get what you're saying, that it would be within the bounds of the Constitution, but it would be an attack on the checks and balances. Right?
Oh, it would be politicizing the court further. Let's be clear. If the Democrats' complaint is that Republicans are politicizing and making the court illegitimate, well, 2 wrongs don't really make a right. This would be a move to further politicize and throw legitimacy questions into the mix.
I mean, so my own view is that what Republicans are doing in a way is hypocritical, but I mean, ultimately they're having a president nominate a nominee for an empty seat and the Senate confirm it. That seems to me maybe hypocritical, maybe you don't like it, but it's within the bounds of normalcy. Whereas court packing, to me, seems extreme. Do you think that the two are noticeably different, or are they comparable?
Well, just based on the history, they are different in the sense that, this is more about how Republicans talked about what they were doing with Merrick Garland 4 years ago than what they're actually doing then versus now. Historically, there have been 29, this is now the 30th vacancy arising on the Supreme Court in a presidential election year. Every single one of those times, the president has made a nomination. And the result of that nomination almost entirely depends on whether the same party controls the Senate as the White House. When it's united government, 17 of 19 nominees have gotten through. When it's divided government, only 2 of 10, and one of those was after the election in the lame duck. So just not knowing anything else about the political moment or who's running for president or anything else, in 2016 you would have expected there not to be a confirmation. And in 2020, you would expect there to be a confirmation. But again, everything else, politicians flip-flopping is obviously nothing new. And if anything, Mitch McConnell is being less hypocritical than almost any other senator on either party, because he, from the beginning, said, well, it's divided government. Obama won, then we won, and we need a rubber match to decide it all, which is different than simply saying, we just don't do it in the 4th year of a term.
So your book, Supreme Disorder, Judicial Nominations in the Politics of America's Highest Court, has a lot of historical analysis. And so I'm wondering what you think. Give people a tease so they go to Amazon and buy the whole thing. What is it that people don't understand about the Supreme Court and judicial nominations that you want to teach them or bring them in on in this book?
Politics has always been a part of judicial nominations and confirmations from the very beginning. I mean, all the Constitution says is that the president shall nominate and with the advice and consent of the Senate shall appoint judges on the Supreme Court. That's it. That's all it says. And advice and consent means whatever the Senate wants it to mean. So historically there was a lot, probably more advice in the early end before the formal nomination was made. You had to placate different factions of your party, regional interests, eventually religious seats, the slavery question, all of these things played into it. And, we went through periods where there were a lot of confirmations and we went through periods where it was very contentious. But a lot of presidents have had trouble. Even George Washington had a nominee rejected. From Andrew Jackson until Abraham Lincoln, only 8 of 21 nominees were confirmed. But then from the late 1880s through 1968, all but 1 were confirmed. What's different now isn't so much, social media or televised hearings. That's what's made the hearings worse. And we didn't always have hearings. That started in 1916. What's different now is, first of all, you have a court that's very, very powerful because of the centralization of power in Washington, and then the skewing of that power away from Congress towards the executive branch and the administrative agencies. And so every year, Congress is forced to, the Supreme Court is forced to and does decide all of these huge political controversies. So every one of these seats is important. And at the same time, we have divergent interpretive theories mapping onto partisan preferences at a time when the parties are more ideologically sorted than they've been since at least the Civil War. So, of course, every time one of these precious seats opens up, you're going to have DEFCON 1, zero-sum game, fraught fight over it. And so, all of these reform proposals that go to the process or the symptoms of the problem, don't address the underlying issue, which is this warping of our federalism and the separation of powers. Ultimately, they're rearranging deck chairs on the Titanic being the ship of state. The problem, the government having gotten to be so big and skewed within it that it's taken decades for us to get here. So it'll take decades for us to push that power back to the states and the people and rearrange it. So Congress is forced to resolve political differences and cultural clashes and what have you, rather than the courts. That's ultimately the only way. Let California be California and Texas be Texas, and make protesters protest Congress, not the Supreme Court. Basically, that's the only way to reduce tensions in Washington generally, but including in the marble palace of the highest court in the land.
Well, there you go. And for people who want to learn more, it is Supreme Disorder, Judicial Nominations, and the Politics of America's Highest Court. The Amazon link will be in the description below.
And now, I tell you what, Brad, if your listeners go to supremedisorder.com, not only can they go to Amazon or the independent bookseller or whatever, but for free, you can download a bonus appendix PDF of statistics and historical data about every Supreme Court confirmation that we've had, as well as a few things about lower court fights.
Well, what good libertarian nerd could say no to that? So before I let you go, I have one thing I ask every guest that comes on this show now. What is your most controversial food take, or the thing you like that grosses people out? Because we all know I have many.
Well, of late, I've really gotten into kimchi. That's the fermented cabbage. That's a Korean staple. They eat it all the time. I like it extra spicy as well, but it's very pungent. My wife hates it. If I open it up, like in the room the next room over, she smells it and she says, "Oh, get that away." But it's very healthy, good for your gastrointestinal health. But more importantly, in these COVID times, I call it our family COVID tester, because a good way of knowing whether you've lost your sense of taste or smell is by opening up one of those jars of kimchi.
All right. Well, I wasn't expecting us to talk about fermented cabbage, but that's just where the show went up. So thank you so much for joining me. And thanks to everybody for tuning in. It's been great to have thousands of you listening to the episodes so far in our new show. And if you want to support the show, be sure that you're subscribed to us on Apple, Spotify, and YouTube, and leave us a 5-star rating and review on iTunes. It really helps. That's it for this week, and talk to you all again next week.
You are listening to Breaking Boundaries with Brad Palumbo.